going to call our last call of the day, and that is people of the state of Michigan versus Michael Carson. This is a calendar case, a grant, 20-minute arguments on each side. My understanding is that the defendant, you will be splitting your time with Mr. Friedman for CDM, is that correct?
Yes, Your Honor, I was going to announce that when I get out.
Okay, sorry, didn't mean to steal your thunder. And then there is a separate argument by, is it Mr. Scher? Scher, okay. So again, 20 minutes each side. You have 2 minutes of fire free that you're able to waive. Mr. Allen, if you'd like to reserve any rebuttal time, just we ask that you keep track.
Thank you, Your Honors. Chris Allen, Assistant Solicitor General on behalf of the people. With me at council table are Assistant Attorney General Brent Morton and Michigan Solicitor General Ann Sherman, and I plan to reserve 2 minutes for rebuttal. U.S. Supreme Court precedent imposes guardrails for a Fourth Amendment particularity requirement, identifying the place to be searched, the evidence to be searched for, and importantly, the crimes to which that evidence must relate. This warrant checks each of those boxes. On its face and in practice, this warrant does not allow an unfettered review of Mr. Carson's phone. There are both constitutional and technological limits that the Court of Appeals did not consider. First, as a constitutional matter, People v. Hughes makes clear that the scope of a search warrant in the searching officer, hems in the searching officer's judgment. Any search must be, quote, reasonably directed to uncover evidence of the criminal activity as identified in the warrant. Here, for example, law enforcement would not be permitted to search for data from several years ago on Mr. Carson's phone. It would be unreasonable. Hughes creates an important guardrail. Second, and distinctly, technology restricts law enforcement from searching certain data that would be accessible to a typical cell phone user. The Court of Appeals asserted that police could always rummage through third-party apps like health apps or banking apps or data that's held in the cloud. But that assumption is simply wrong. Where passwords are required by the user to access an application on their phone, the data is typically inaccessible and encrypted. And data that's stored in the cloud, whether it's Google Drive or Dropbox, that's not located in the place to be searched, here the cell phone. So it's outside the warrant's ambit. For those, law enforcement must and will get a separate search warrant directed to the third parties. And even if the particularity doctrine were violated, severance here requires reversal. The majority below did not grapple with severance, even though it acknowledged that in its judgment, text messages between the co-conspirators would be wholly appropriate to search for. I think the additional issues of good faith and effective assistance of counsel also run in the people's favor, but this court need not reach those issues. So I wanted to double back to People versus Hughes because I think it's something the Court of Appeals did not consider, and I think it's highly relevant because it imposes these guardrails about what the search actually can and can't do. And first of all, the search warrant in that case I think mirrors this one in a lot of ways, in that the scope permitted imaging the entire phone, as this court described in that case, and then reasonably searching with an eye towards the crime that was identified in the warrant. And this court made clear that there's that the search must be, again, reasonably directed toward uncovering evidence of the crime. Law enforcement is not willy-nilly able to go through and search anywhere on that person's phone, wherever they'd like, looking for evidence of a crime or this crime. It has to be reasonably directed in that way. And this court created 9 or 10 different factors to consider when a Hughes type of claim is raised about the scope of the search. Now again, we're not talking about the scope of the search here, we're talking about the particularity, the four corners of the affidavit, but those doctrines go hand in hand. So too do the doctrines of requiring a probable cause to support the search warrant. The nexus requirement, making sure that the nexus from the affidavit links up with the scope of the warrant itself. And so each of these doctrines are, certainly they're related, but they're independent restrictions or guardrails on what law enforcement can do. It is not as if the particularity doctrine is the only thing standing between law enforcement and just rummaging through people's cell phones.
Counselor, you've mentioned a few guardrails. You mentioned timing that several years ago, and you also mentioned the idea that, the cloud wouldn't be searched, for example. And I know that on my phone, I can just click on my stuff in the cloud because I'm lazy with passwords, probably.
Sure.
And so why isn't the lack of specificity, I'll use that word instead of particularity, in this warrant just shifting all of the discretion about what's to be searched to the officer who's doing the searching? And why shouldn't we require that in the warrant itself?
Well, I think, first of all, the Constitution doesn't require it. I think, first and foremost, that's what we're looking at is, what does the Constitution require as far as particularity is concerned? Not what is the ideal or what would be greatest in our individual judgments, but what does that Constitution say? And I think it's important to look at the language of the warrant itself, and I think some of the cases that gave rise to it. I know we're talking like 18th century here, but it gives life to what the Fourth Amendment means and also what a general warrant, an improper general warrant, really means here. And so, the Fourth Amendment requires that a warrant must be issued upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the things to be seized. The kind of genesis of that language comes from, I think, a couple of pre-revolution cases we alluded to in our brief. Entick versus Carrington, Wilkes versus Wood. These are kind of the paradigm general search warrant or general warrant cases. And in those cases, there was no evidence to support them whatsoever. There was no identification of who they would be searching for if it was an arrest warrant, where they could be searched, the place to be searched didn't have to be put in there. And so those are the hallmarks of what a general warrant is, and therefore what the Fourth Amendment was intended to protect against. And so, to get back to your question, Your Honor, first, the Fourth Amendment just doesn't contemplate that. It hasn't, whether it's in someone's home, which, that's the more familiar type of search warrant because, we had homes well before cell phones. But in, for example, Anderson versus Maryland, that detailed a fairly broad or I think a comparable search warrant to what we have here, in that it permitted law enforcement to search for a host of documents and then at the end, any and all instrumentalities or contraband or evidence of crime. And it didn't even identify the crime there. And this court, the U.S. Supreme Court said that met the particularity requirement because, in part, it referenced the false pretenses crime earlier in the warrant. And so the breadth of the warrant is comparable to what we have here. Now, I understand a home is not a cell phone, but the work that Riley did in really changing the landscape quite a bit was from permitting law enforcement to, search incident to arrest, to get someone's cell phone and just go through it as if it were any other item or article. That's gone now. So what the Supreme Court did was it saw fit to, because of these privacy interests that we all recognize that the people do not dispute, because of these privacy interests, you get a warrant. And the court made no suggestion or even hint that all of the requirements that applied to warrants for homes going back centuries were somehow now changed. The same warrant requirements, the same nexus requirement, probable cause, particularity, scope of the search, those all apply now in a way that they didn't before 2014 in the court's Riley decision. And so while it might be more protective of privacy to require more specific things and specific descriptions in every case, simply that's not what the Fourth Amendment requires. And it also, you're right in the sense that it does give law enforcement more discretion. But that discretion is really, I don't want to say limited, but it's hemmed in by People versus Hughes. And I think the court was very careful in making clear that this is not carte blanche to look at someone's phone start to finish. And I think one piece of the search warrant here and in any other one that would pass muster, the identification of the crime, that's something I think the opposing side has really minimized as not doing any work, the Court of Appeals as well. That does a lot of work because it not only limits the type of content that would be reasonable to search for. I think depending on the nature of the crime, how far back in time can you look in that person's phone? And that's going to...
Do we have anything in our record about this specific search, that there was any limitation on the time, the dates that were searched, or the locations within the phone? Or is there any record on whether that it was in fact limited?
The defense did not develop that kind of record. I know that there were a few questions at trial to the forensic examiner about what they came up with, but that wasn't really challenged below. I think implicitly there was kind of a general challenge to this search was just too broad, but that wasn't developed below. So I can say no, we don't know in this case because that wasn't really advanced by the defendant and wasn't developed as part of the record. So we don't know in this particular case, but if there was a Hughes claim brought, then that would be ripe for scrutiny. What did the officer do? Did they look back several years in a manner that would be unreasonable? Did they look at a particular kind of document that would be unreasonable to look for absent some other indication? And I think the identification of the crime is what helps make this kind of a case-by-case inquiry, because in, for example, an investigation for child pornography or certain white-collar financial type crimes, those are going to have a much longer look-back period because the nature of the crime contemplates that if you obtained some child pornography 10 years ago, that's highly relevant. That's the ballgame for that conviction. So it would be entirely reasonable in that case to look back further to identify that kind of evidence, or in a banking case, whether that wouldn't be so much cell phone related, but just the general idea of a warrant is limited to the nature of the crimes. If it's a heat of the moment sort of crime, where the nature of the crime, the facts known to the officers at the time, just sort of arose one day, it might be reasonable to look back a couple weeks or months, or it's going to depend on the nature of the case, but it wouldn't make sense to look back years and years, because again, that would not be reasonably directed toward uncovering evidence of that crime. And so that piece of limitation, I think, does a lot more work than the Court of Appeals gave credit for.
What do we make with Groh versus Ramirez? So there, the court looked just to the warrant itself. It rejected looking to the underlying affidavit, and it also rejected sort of a after-the-fact reasonableness inquiry, which feels like what you're inviting us to do here.
The reason I raised People versus Hughes is not because it has to do with strictly particularity, but that's a separate claim that can be brought. The particularity claim in Groh was found to be not particular because there was simply nothing identified in the part of the warrant that would require you to show or to establish that we're looking for evidence of this crime. That was completely absent. And so that it's not even a close case because it just facially violates the Constitution because it doesn't particularly describe the evidence to be seized. That is much closer to a potential general warrant because officers in that circumstance could look at whatever they want without restriction because there was no limitation of the crime and the evidence on that phone. And so I think Groh kind of stands as a bit of an outlier, but an important one to show that the court takes seriously. If a search warrant doesn't contain these elements, then it's going to be found unconstitutional, and it should be. But that's not what we have here. And that's a lot of the cases that the Court of Appeals and the opposing counsel and Amici cite to is cases where there was no crime identified. And what does that do? That opens up discretion for officers to go wherever they want. And it really provides, the only meaningful limitation then is the place to be searched, which is of course meaningful, but not when there's an absence of a limitation on the types of things to be searched for.
Counsel, I'd like to skip ahead on the issues. Let's just assume I don't agree with you.
Sure.
And then we get into the realm of whether there was ineffective assistance and whether there was prejudice here. The trial court here, I think, made a statement along the lines that she thought that the text messages made a difference in the outcome. Is that something we should consider or not?
Well, I don't think you need to reach the issue, if that's your first question, but sort of assuming that you do. The text messages were highly damning. I mean, they were essentially admissions. You probably could have prosecuted the case just on those. But the fact that those weren't there, there's substantial evidence that was admitted. And I think the Court of Appeals here actually did a not so much in its holding, but it's in its description of the evidence adduced at trial. The amount stolen, the access that was only given to these, to Mr. Carson and Ms. DeGraff, the testimony from their housemate, roommate, Mr. Olson, that he found, or that he saw evidence in these, money in these $1,000 bundles with the yellow bands, which are precisely the thing that Mr. Billings, their elderly neighbor, had in his safe. There was the highly increased activity at the casino immediately after the access was given to these individuals to his house. Tens of thousands of dollars suddenly spent, even though, and also Mr. Carson quit his job a few days within getting access to Mr. Billings' house, and he told his boss he just came into some money. He happened to come across, I think, a trunk full of valuable things. I don't believe there's record evidence that actually existed. So even without the text messages, if those didn't exist, I think this is still a very, very strong case. It's not as if the text messages here were the silver bullet that took an okay case to an easy one. I think without the text messages, there's no reasonable probability that this case would have been any different if particularity were an issue, if severance didn't apply, and if good faith also didn't apply. One of the things that was offered by Amici are these kind of different species of limitations that this court should consider, like a temporal limitation, a content-based limitation, and a search terms, kind of building in search terms into the warrant itself. And I think there are, some of these limitations are worse than others, but none of them are required by the Constitution. So I wanted to start with the search terms-based limitation. This court alluded to, there's maybe a discussion in Hughes, one of the footnotes, that this has sort of been out there. I've not found any federal appellate cases that have adopted this, and no state cases as far as I know. And I think there's a couple of reasons why requiring officers to show their work before they've been able to see what the scope of what they're looking at is. Number one, it really puts magistrates right in the middle of a criminal investigation, which is troubling in a way. Certainly they have to evaluate for probable cause and nexus and whether the warrant is sufficiently particular, but investing the magistrate essentially into the criminal investigation feels like it has separation of powers concerns. It also is unreasonable to expect law enforcement officers to know what they simply can't know yet. And so that, I think, would be the most disruptive and problematic for a few reasons. Another type of limitation that was suggested by Amici was a sort of a content-based limitation. You can look for photos, but you can't look for text messages or whatever. Those distinctions break down pretty easily. For a pretty clear example here, the Court of Appeals said you could look at text messages between these two. That would be reasonable, but it would be unreasonable to look at photos. Well, there are many, as we know from Riley and as we know from practical experience, people take photos of all manner of things. People use their phones for all manner of things at all times. And certainly that informs why there is now a warrant requirement to search a phone, but to ignore it on the other side, to say, well, how would we know that this person would have taken photos that could be potentially incriminated? And they don't have to be photos of the safe to be relevant to a criminal investigation. They could be photos that show that they were, the metadata shows they're in a particular place at a particular time that is incriminating or exculpating, potentially. If you unduly restrict the sort of data types based on, what we're really, it overly, I see that I'd like to finish my answer before I sit down. That is another limitation to be imposed that's not required by the Constitution and would really lead to hamstrung law enforcement investigations. With that, I'll reserve the remainder of my time for rebuttal. Thank you.
Thank you.
Good morning, Your Honors. May it please the Court, J. Nicholas Bostic on behalf of the appellee, Mr. Carson. I would like to share 10 minutes of my time with Amicus for CDAM, the ACLU, and the Electronic Frontier Foundation. That would be Mr. Friedman. The Court of Appeals should be affirmed because when the United States Supreme Court decided Riley, they took cell phones outside of the exception to the warrant requirement of search incident to arrest. They specifically said you have to get a warrant. That phrase automatically brought the particularity requirement with it. What it did was it put the particularity requirement in its very important position in Fourth Amendment jurisprudence when we're dealing with electronic data versus physical objects. I disagree with the state that there was any heightened requirement. Some of the cases talk about particularity having special importance or special prominence. That's what I'm talking about. It has a very important position in Fourth Amendment jurisprudence because of the electronic data as opposed to a physical object. Some physical objects create their own limitations by where they can be placed. Electronic data does not. Now, if you're looking at the download, the forensic download, you're not going to be looking at the internet. But if you're looking at the phone and searching through it, you might actually be looking at something on the cloud instead of something that's on the phone. Justice Thomas, to answer your question about what do we know about the scope of the actual search, it's fairly limited, but Exhibit C, admitted to the trial court, was the first 2 pages of the Cellbrite report. And that is also in my appendix at pages 103 through 104. And then we have the trial defense counsel testified at the Ginther hearing about receiving approximately 1,000 pages. And when you look at the Cellbrite report, on the second page at the bottom, there's a table labeled contents. There are 18 different data types, I'll call them. And then there's a middle column, and it says included in report, and it gives it numbers. Then there's a third column, and it says total. Of all 18 data types, only one had a discrepancy between the included in report and the total. And that was the images. For some reason, the total images in the report was 978. The total images in the extraction was 979. So I think that's what he was referring to. Of course, there's more than one thing on a page, but that included, that 1,000 pages, I think by strong inference from the record, included the entire phone.
Counsel, what would have fixed the warrant here? How should they have drafted it?
Well, first of all, it should have had a time limitation.
Okay,
As we know, you get a new cell phone, you bring your old cell phone data into it, and it goes on forever. So the time limitation is the big one.
I mean, I get the difficulty that it's different than a home, right? A search of a home, but, Judge Redford pointed out that, the warrant talked about records or documents pertaining to investigation of larceny of a building in a safe building. Would that have been okay for a home? Could you go through filing cabinets and, try to find things that, would that have been okay for a home?
If the probable cause supported that you were looking for a document, then your physical limitations are basically none. Yeah, you can look anywhere that a document could fit, but if you're looking for a book, now you have a few more limitations. If you're looking for a set of books, you have even more limitations because you're dealing with physical objects. That's where the particularity clause has become extremely important, and we get that from Riley.
So I want to just turn to the notion of severability. And I realize your other brother counsels can, chime in on this too. But if the warrant had sort of more specific, maybe bullet-pointed items or something, or bullet-pointed things, text messages, photos, like, I mean, maybe like something more specific. Would you say that would be severable then? Could they save the warrant?
Only if each category was supported by probable cause. So I would like to dive into that severability just for a moment.
Sure.
So when I say paragraph 2 of the warrant, I'm talking about paragraph 2 of our state court administrative office forms. So paragraph 2 is the property to be searched for and seized. The first sentence of that paragraph says any and all and contains the purported limitation of identifying the crimes. So any and all records and documents. The second sentence is a definition of the word documents, which inarguably is about as expansive as you can get. The third sentence is the one with many, many, many clauses in it. And those clauses all refer, well, not all, but most of them refer to actual physical objects which cannot be in the phone. One of them is even other cell phones, other cellular devices, physical keys, encryption devices. It sounds like even some of that would be referring to facial recognition, eye scans, thumbprints. It really is extremely expansive, but the problem there is, and this I think leads to facial invalidity too, it can't be in the phone. Well, that's what paragraph 1 says we're searching. The fourth sentence appears to really be the operative sentence, and that's any and all data. And it mirrors the first sentence a lot, although it doesn't have the limitation by naming the crimes. But it has a phrase in it that talks about specific things, such as text messages, text picture messages, pictures and videos, address book, any data on the SIM card. So when we get back to our required reading of this in a realistic, common sense manner, that additional phrasing is not limitation, it's expanding the concept of any and all
So if
data.
it had stopped and not had that, if it just said text messages, pictures, videos, address book, would that have been all right?
If you agree with the Court of Appeals by saying that there's a fair inference that they communicated with each other,
Yeah, let's just assume
obviously
that, yeah.
it would be. However, I disagree with the Court of Appeals on that inference. But and I keep wanting to jump off into probable cause, but that's not why we're here. It's hard to answer a question about would a warrant, phrasing in a warrant, been valid without acknowledging the caveat, it has to be supported by probable cause in the affidavit. So there's actually one category. If you look at the first sentence and you look at the fourth sentence, you're really only talking about one category of evidence, which is interesting. They didn't use the word evidence in the affidavit. What evidence are you looking for? He didn't use that. He used data. So there being only one category, there's nothing to sever. Because if we follow the Keller application, first you sever, you separate the categories. There's really only one category that they're looking for. So there's nothing left to sever.
Can I, just in the, we have about a minute left before you share your time. Can you address, even if we were to agree with you on the particularity and severability is inapplicable, what do we do with good faith and or IAC? I mean, so how can you say that an officer who relied on this warrant that was sworn and issued by a judge, and arguably this is this is why we're here debating it, is an issue sort of a first impression. Why does good faith not apply?
The third sentence of the property section in paragraph 2 seeks to seize items that are physical objects that cannot be in the phone. that goes to the lack of good faith. It's facially jumps out at you that we're looking for physical items inside of a phone. The fourth sentence has no time limitation, and the absence of a time limitation for a device like this with that much privacy data in it after Riley jumps out at you. The SIM card issue brings in the concepts of Carpenter, because now we're talking about location data. There's no time limitation. We're looking for SIM card data. His training and experience is not specified. The Cellbrite report shows that the entire contents of the phone were generated in the report that was produced. Those types of things, I'm looking into the affidavit now for the good faith analysis. There's so many things that jump out at you immediately when you read this warrant that you cannot possibly believe that it satisfies Riley, which was decided in 2014. And I think that's really where it comes down to on the ineffective assistance as well.
Okay, thank you. If you want to reserve it, Mr. Friedman.
Thank you.
Thank you.
Good morning. I don't know if I have any free fire time, but I waive it if I do. What I'd like to do is, when I was listening to the Attorney General argue, one of the things that caught my attention was how much he spoke about the methods that the officer would use to narrow the search warrant that weren't written into the search warrant. So to answer one of the questions that the court has been grappling with, I would suggest that writing some of those things in might be your first line of defense that tells an officer what they must come back to the court for. The officer knew he shouldn't search medical data, but an officer could just as easily say, how did I know that he didn't hide either blueprints for this burglary or safe cracking as a medical file? Now, I have to caution myself today, because I'm a geek and a tech, to keep my knowledge of the technology to myself. But what I want to say is that he's doing that constantly. It says, well, they wouldn't go back in time, they'd be focusing on this incident. But if you read the first sentence, which we've been dwelling on, it says all records or documents pertaining to the investigation of the larceny in the building, not limited to it. So we listened to all this evidence in this case about unexplained wealth at the casino. Well, what about prior debt? You could theoretically go back years on that. I mean, none of these things are dealt with. There isn't a temporal limitation. I was listening to my opponent say, well, there aren't many cases in the criminal arena that talk about text words as a limiter, and that Hughes may have been dicta on that, notwithstanding the discussion that police could not go on a suspicion searching through every part of a cell phone on the possibility and speculation. And this is quoted in the lower court opinion in Carson from this court nearly verbatim. So I think you need to look at what the probable cause is and what is just complete speculation. One of the things that can be considered, and if that's the case, put it in the affidavit, is if we know if we've got a defendant who is particularly tech savvy or hides behind these stealth applications. I mean, I'd be in trouble if you wanted to search my iPhone, because I've been jailbreaking iPhones since they were released. But most people just use them as the factory intended, and if we've got the outlier case, say so, and that expands it. He was talking about metadata explaining the location of a search. Well, obviously data it's accumulated at the crime scene is going to be, they're going to have a broader line of inquiry, because that in and of itself deals with the crime, whereas data that goes back in time, I would submit, doesn't. Data that's not at that location to a lesser extent, but obviously it could be related. So those are the things courts could talk about, but what we've got instead is trust the line staff. And one of the things as I was listening to this is the Attorney General sounds very reasonable here today, but I was wondering how this would play out in the courts and with the police around the state, and whether they would make such concessions. I've got one case before this court currently on an application hopped, which I would suggest is contrary to the position asserted here. Turning with respect to the severance issue, there's only one sentence that describes the crime. Everything else really describes data in the most expansive set. In many of the cases that deal with redaction, we have items that break down. A, all this. B, all that. But they define those. So you can say, we'll line out the catch-all, or we'll line out C and D. But you would have to do reconstructive surgery. And that brings me back to what I heard this case open with, which is, well, the officer can read in this limitation. The officer can read in that limitation. But if the officer doesn't choose to read in that limitation, then we fall back on good faith, and we would lose. And I'm going to suggest to a certain extent, this is largely the situation of reading the last chapter of a murder mystery and then going through your redaction of the earlier chapters. You know the result, you know what's critical, and then you propose the redaction. So you actually reward them in engaging in broad wordsmithing, knowing that they're going to have to go into court later on and redact things out, but they can redact out the things that don't really harm them. This is the quintessential open-ended warrant. It's what Gates talked about. I believe that's, and don't hold me to this, but when Hughes ultimately was reversed below, I believe that was one of the things that they said, is that it was a bare bones affidavit. If I'm wrong, I'm wrong. I see you look there, Justice Kavanaugh. But there are ways that we can approach this, and we're doing it in civil cases. As we were grilling the parties on the Grow case, and the Attorney General was mentioning we don't put a keyword limitation in, I just quickly did a Lexis search, and I'm seeing that in the civil arena, they're being told to do this all the time, and they're offering it. Privileged communication. Yes, sometimes offenders do rename documents. They do turn around and say privileged communication with my attorney when it's really the blueprints to burgle the bank. But it should be something that would send them back to the courts. And it's something that the line officer, since we don't have taint teams, shouldn't be making that decision on. So again, we could put in language in a warrant telling them when to come back, when not to just use your own judgment, and that would go a long way. So I don't believe that the sky is falling. I think the Fourth Amendment is actually what would be falling if we uphold this approach. That concludes my speech, but I would welcome any questions, because I see faces that suggest doubt to a certain point, and I think this is an important issue that the court needs to address. We need guidance, and I will add some concern about future proofing.
Well, your last point about that you need guidance, and your brother counsel said that on the good faith question, that on the face of the warrant it's so facially invalid. Do you need guidance on it? Is this still sort of an evolving area of the law that, should be, we're in the realm of the good faith exception, or is it so facially clear and that it's facially invalid and good faith wouldn't apply?
If you go back to the trial court's opinion here, they actually found that the motion to suppress should have been filed, that it was an issue that was significantly enough in play, that the party should have been alerted to it, but ultimately saved it on other issues. So that may not be addressing the good faith, but it does address the ineffective assistance of counsel. My job as a criminal defense attorney is not to turn around and say, I'll probably lose this motion, so I shouldn't file it. I should, particularly on serious offenses, leave that to the judiciary. By the time that the search occurred, we had Riley. We had a lot of things that put the officer on notice. And I see that I am effectively out of time. I think I've suggested how we can fix it in the future. I don't see how this warrant is any different than the Hughes case.
Okay, thank you, Mr.
Thank you.
Friedman. Mr. Sher, you have 5 minutes.
Thank you, Your Honor, and thank you for allowing us to present our perspective on this very important case. Let me just add 2 brief points to the excellent presentations that have been made by defense counsel and by the other amici. Number 1 is that the warrant at issue here is a general warrant, as that term would have been understood at the founding, and as that term has been understood and applied in U.S. Supreme Court cases. Indeed, the warrant here is closely analogous to the general warrants that were actually struck down by founding-era English courts, consisting of warrants that authorized an extensive search of a dwelling for any documents that might be relevant to a particular investigation, say for failure to pay British taxes on tea or sugar. And under the U.S. Supreme Court's analysis in the Stanford case, which I also think is highly analogous to this case, that kind of a warrant constitutes a general warrant even where it's limited to documents related to a violation of a specific statute. In fact, the warrant that was struck down in Stanford as being a general warrant was even more specific than the warrant at issue here, but the court still held that's a general warrant. Now, although a modern cell phone or a modern smartphone is physically the size of a small notebook, as we all know, today it's capable of holding the equivalent of an entire room full of paper documents. And so this warrant, in contrast even to the warrant in Stanford, the warrant here contains no real limits on the records on the defendant's phone that the police could search. As has been noted by its terms, it extended to, quote, any and all data on the phone, and even, quote, any data, image, or information that is capable of being read or interpreted by a cellular phone or a computer. So there were no limits on the types of files, no limits on the dates on which those files were created or were modified. There were no limits on the types of apps that could be searched and data generated by those apps. The only limitation is a supposed limitation on the type of information. The only limitation is a limitation of purpose, namely that the warrant it was limited to anything pertaining to the investigation of larceny in a building and safe breaking. But again, that's like the general warrants in the colonial era, where officers were allowed to search for any records pertaining to specific alleged violations. It's similar to the very limited limitation in the Stanford case, and in reality, it's no limitation at all. And if anything, the Court of Appeals was probably too generous in calling that limitation a guardrail. My second point, if you affirm the U.S. Supreme Court, I'm confident, will be with you. We think the Court of Appeals decision here follows ineluctably from the U.S. Supreme Court's decisions in Stanford, Riley, and Carpenter, as well as this Court's excellent decision in Hughes. We recognize, of course, that this Court could avoid any risk of further review by affirming only under Michigan's version of the Fourth Amendment without opining on the federal Fourth Amendment. But we believe that would be a huge lost opportunity. As this court is obviously aware, other courts are struggling to determine how exactly the Fourth Amendment applies to modern technology like smartphones. And this case gives this court an excellent and invaluable opportunity not only to protect Michiganders' privacy, but also to add to the growing chorus of courts across the country that have embraced a robust understanding of how the Fourth Amendment applies in the modern digital age, and thereby provide guidance to other courts and indeed to the U.S. Supreme Court if it chooses to wade into these waters again down the road. And we respectfully urge the court not to let that opportunity pass, but instead to make clear, as Carpenter did and as Hughes did, that courts interpreting the Fourth Amendment should, as the U.S. Supreme Court put it, should preserve that degree of privacy against government that existed when the Fourth Amendment was adopted. Thank you.
Thank you.
Your Honor,
You can lower that.
I just have a couple points. First of all, there's no Michigan constitutional claim at issue here that was never raised or briefed or addressed. If this court saw fit to look at that type of claim, whether the Michigan Constitution requires anything else, that would be a different case down the road as far as the particularity doctrine is concerned. Second, the Stanford case is really not instructive here. The Stanford case was a 1965, really like a Red Scare era case where the state of Texas was investigating someone for being a member of the Communist Party. And so part of their search warrant, or their entire search warrant, was to look for books and pamphlets that would have evidenced that. The U.S., I'm not sure how that was still a constitutional charge, but apparently it was at the time. The U.S. Supreme Court found that that was improper because it so held the First Amendment freedoms kind of intersected with the Fourth Amendment freedoms here. And that's why in that case there was a heightened particularity requirement. That case has not been extended beyond its terms, and in fact, Anderson, which we've relied on extensively, which considered a warrant that is really substantially the same as what we have here in terms of its scope, that came after the Stanford case. And so it's clear that Stanford was a one-off in a particular area, and it would not govern this case. I also wanted to address the opposing counsel, talked about how difficult in his position it is to separate the requirement of probable cause from the scope of the warrant. And I think that speaks to the nature of the claim that is really brought here as a nexus claim. The Court of Appeals below did not, in its majority opinion, discuss the proper nexus. I think it was raised. If I may finish just briefly, Your Honors.
Absolutely.
So the gravamen of the claim here, as counsel said himself, is that he has an issue with the nexus. Now, we think that's proper, but it's also not before the court. That, I think, further indicates why, changing in a really substantial way the particularity doctrine is not in this court's interest as far as it is interpreting the Constitution. If there is a problem with the nexus, that's a separate claim that should be adjudicated. This court could reverse and remand to do so because the Court of Appeals did not in full consider that claim. With that, I entertain any other questions. Thank you, Your Honors.
Thank you. The case will be submitted, and the court stands adjourned, the end of our April call. Thank you.